So, Marcelo.
Hello, good morning.
Well, we say good morning because in Brazil.
Yeah. Hi.
I think it's afternoon somewhere where you are.
Recording in progress.
Greetings, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Fernanda Suriani, and this is the second panel of the second day of the event. I'm very glad to be here with you. It's an honor for me to share these moments with all these brilliant panelists. Before starting the panel, I'd like to thank our sponsors. Our platinum sponsors are JUS Brazil and Albert Einstein Israeli Hospital. JUS Brazil is currently the #1 law and government website worldwide, with 28 million unique users each month that makes high-value legal information super easy and quick to access, thus saving its users time and providing substance for their case strategies and insights. Our other platinum sponsor is Albert Einstein Israeli Hospital, one of the best-known health units in Brazil and Latin America, for the quality of care and for the equipment and medical specialties available to treat main types of pathologies. The hospital is actions, teaching and research activities. Now I would like to introduce Ms. Heng Zhang, who will present the full paper with the title Hardness of Case-Based Decisions, a Formal Theory. The stage is yours, please.
Thank you. I'm now going to share my screen. Yes. Hello, everyone. My name is Heng Zheng. I'm a PhD student from the University of Groningen. Today, I'm going to talk about our paper, Hardness of Case-Based Decisions, a Formal Theory. Following precedence is a fundamental principle of case-based reasoning, but the application of it varies in complexity. Legal decision-making can still be very hard. This puzzle has been well recognized in AI and law since its early days. For instance, in Anne Gardner's landmark work, An Artificial Intelligence Approach to Legal Reasoning, she addresses the distinction between hard and easy cases by using ideas from jurisprudence. The hardness of case-based decisions can come in different types. Some cases are easier to decide. However, things can become harder. For instance, not all conflicts can be resolved, or there is no matching precedent. Significant work has been devoted to the nature and dynamics of case-based reasoning and to the hard cases as well. However, to the best of our knowledge, no formal theory about the hardness of cases has been proposed so far in the field of AI and law. So in this paper, we are going to discuss this question. Is there a typology of how hard it is to make a decision about an issue in case-based reasoning? We propose a formal approach written in propositional logic to formalize the hardness of decision-making issues with the validities of relevant arguments. We also illustrate the approach with a case study in the dynamics of case-based reasoning by following Berman and Hafner's research, thereby showing how hardness varies over time. This slide shows the 7 cases that we are going to discuss, which aims to solve tort cases about car accidents from New York. With the elements extracted from these cases, we got 7 conjunctions to represent them. They are represented by the plaintiff's name, the year of the decision, the kind of case, either a tort case or a contract case, and the jurisdiction choice rule. We need to consider which rule should be applied when different jurisdictions are relevant. For instance, when people drive from New York and have an accident in Ontario, Canada, which rule should be followed? Ontario's rule or New York's rule? Your territory is for entirely applying the territorial rule. Exception is for partly applying the territorial rule while making an exception for the damages part of the case. And gravity is for applying the center of gravity rule. In this paper, we try to apply our approach to solve problems such as if there are only these 2 precedents can be considered, how hard it is to apply the territory rule in an undecided tort case that arose after 1945? And what about the hardness of applying the center of gravity rule? And after new cases were added, does the hardness of applying rules change? And does it become harder or easier? In general, we consider these four issues of the New York cases, namely, whether to apply the territory rule in tort case or not, whether to apply the gravity rule in general, whether to apply the exception about the territory rule, and whether apply the gravity rule in tort law. As you can see from this picture, there was an agreement in decisions that the territory rule should be applied in 1938, so decision-making was easy at that time. However, from 1945, alternative possibilities were explored. First is for contract cases, then also for a tort law case called the Cuba case in 1961. Therefore, case-based decision-making becomes harder since there are different possibilities and without a clear preference. And then in 1963, things again became easier, since the landmark Babcock case expresses a clear preference for the gravity rule. Now we turn to the theory part of the paper. First, we are going to introduce case models. We describe a case model C as a set of logical consistent incompatible cases, forming a total pre-order that represents a preference relation among the cases. For example, the New York cases we just introduced can form a case model. And please notice that we consider the plaintiff names to exclude each other pairwise. And similarly, for the decision years, the kind of the cases and the rules. The preference relation among these cases is denoted by the size of these boxes. And namely, the Babcock case is more preferred than other cases, which are equally preferred. This is because the Babcock case is a landmark case that overrides previous cases, by which the center of gravity rule is established for tort law. And we consider an argument from chi to rho is a pair chi-rho, where chi is the full premise of the argument, rho is the full conclusion, and chi and rho is the full position made by the argument. According to the preference of a case model, arguments can have three kinds of validities in the model, from weak to strong, are coherence, presumptiveness, and conclusiveness. The relation between these validities can be illustrated by this Venn diagram. Conclusive arguments are also presumptively valid, and presumptive arguments are also coherently valid. And all the precedents are either coherent or incoherent. If an argument is incoherent, then it is outside the set of coherent arguments. Every argument can be attached to a label based on its validity in the model. An argument with a conc label are those conclusive arguments. An argument with a pres label is an argument that are presumptively valid but not conclusive. An argument with a co-label is coherently valid but not presumptively valid in the case model. And label inco is used for arguments that are not coherent. These arguments are in the set of all arguments but not in the set of coherent arguments. We consider the validity labels come with an ordering. Intuitively, based on their validities, arguments with label conc are stronger than arguments with label pres. Similarly, pres is stronger than co, and co is stronger than inco. With this ordering, we can quantify how far apart the labels are. We call the validity distance between two arguments is the number of steps in the validity ordering that are needed to go from the label of the weaker argument to the label of the stronger one. As the ordering has a length 3, the maximal validity distance is 3, and the minimal is 0. For instance, from con to inco, the distance is 3, while from co to co, the distance is 0. With arguments and their validity labels, we can define issues for discussing the question about hardness. Formally, we represent an issue as sigma plus minus iota, where sigma is a sentence for a given situation. Iota is a sentence as an issue about the situation. Both iota and not iota are not logically implied by sigma. For every issue, there are two naturally associated arguments, namely sigma iota and sigma not iota. For example, when we think of whether to apply the territory rule in tort cases, we consider issue tort plus minus territory, where argument tort territory is for applying the territory rule, and argument tort not territory is for not applying the rule. Similarly, whether to apply the gravity rule in tort law is connected with issue tort plus minus gravity. Whether to apply the exception about the territory rule is connected with issue tort plus minus exception. And whether considering gravity in general is represented with issue tautology plus minus gravity. The type of an issue sigma plus minus iota in the case model C is represented as a multiset consisting of the validity labels of the two associated arguments. For instance, if the argument for applying the territory rule is with label conc, and the argument for not applying the rule is with label inco, then the issue tort plus minus territory is with type conc inco. And by the definition of arguments validity in our paper, not all types are logically possible. Now we show in total 7 possible issue types. And we view hardness of issues, of types of issues, as a relation between types of issues in different case models. Intuitively, a type of issues is easier than another one if and only if the greater the difference between the validity of its associated arguments, or the stronger the validity of the associated arguments. For instance, conc inco is easier than pres, since the difference between conc inco is greater than the difference between pres. And since the validity strength of pres is stronger than inco, we consider pres is easier than inco. As shown by the Haas diagram, in our definition, an issue type that is higher in the ordering is easier. Formally, The hardness ordering is based on the lexicographic combination of two orderings among the types of issues. We first compare the types in D ordering. Higher types in D ordering involve further validity distance between the labels within types. And higher in D ordering means the type is also easier. For instance, the validity distance between con and inco is 3, and the distance between press and inco is 2. Therefore, by the D ordering, we consider con inco is easier than press inco. However, if the types are with the same validity distance in D ordering, then we can turn to the V ordering. Higher in the V ordering means issues involving stronger arguments. Therefore, higher in the V ordering means the type is also easier. For instance, the validity distance of both type press and co are equal to 0. In this case, we cannot compare their hardness in terms of the D ordering, and we need to use the V ordering to decide which one is harder and which one is easier. Since press is stronger than co in the V ordering, we consider press is easier than co. The Haas diagrams in this slide shows our definition of hardness is well-behaved, since it is transitive and can be used for comparing any pair of issue types. Now we connect the hardness ordering with the development of hardness of applying rules in the New York cases. As we discussed before, the hardness of an issue is determined by the validity of the arguments that it associates with. And with new cases being added, the hardness of applying rules will change accordingly. For instance, the hardness of issue taught plus minus territory is with type con inco in 1938. When it becomes harder in 1963, it is with type press co. In general, we figure out that when the gravity rule was introduced in general in 1954, issue tautology plus minus gravity became harder. Similarly, when the gravity rule was introduced to the tort law domain in 1963, issue tort plus minus gravity also became harder. And we also observed that issue tort plus minus territory became harder correspondingly when the court showed doubt on the territory rule by making an exception for the damages part of a tort case in 1961. And in 1963, when the gravity rule was introduced by a landmark case called Babcock case, with higher preference, not only issue tort plus minus gravity became harder, but also other issues are become easier. After finally making the...
Hank, you have 5 more minutes, okay?
Okay. After finally making the gravity rule as the primary one in 1963, the 4 issues remain the same hardness type press co as in 1938, when the primary one is the territory, and they are always type con inco. This shows that more options makes the consideration of applying rules becomes harder than in 1938. So in conclusion, we model the hardness of issues of case-based decisions in terms of arguments and their validities, and define an ordering that shows which issues are harder and which is easier. We also apply our approach to discuss the hardness of the issues in the context of dynamics of case-based reasoning. So the hardness approach we introduce is relevant in the understanding of case-based decision-making and can be applied in other domains where example-based reasoning is reasonable. And it can also lead to insights on the hardness of decision-making in hybrid AI systems involving both knowledge and data. Thank you for your attention.
Thank you very much. We have some questions for you. So the first one is, in your paper, the model case-based decision-making is applied in common law jurisdictions. Do you think it's possible to apply this model in civil law jurisdictions?
Yeah, thank you for the question. It's very interesting, but since it's a very initial research, currently we just apply it to the case law domain, but we believe that it can also be applied to the civil law domain because one of our previous paper shows that it can be, the case model can also be applied in the Dutch civil law system. So yeah, I think it's possible.
Okay, and another question. There are earlier attempts to formalize the distinction between hard and easy cases. For example, Gordon in 1991 and Preke in 1993. Gordon also formalized the notion of an issue. What does your approach add to their work?
Yeah, it's a very interesting question. Thank you for that. But we haven't, I haven't looked at Gordon's work yet. So yeah, our approach is based on recently developed case model formalism by Bart. So yeah, it's in a formal propositional logic.
Okay, thank you very much. Do you like to say a few more words before we go to the other panelists?
Yeah, I think that's it. Thank you for attention.
Okay, thank you very much. Now I would like to introduce you to Mr. Trevor Bench-Capon, who will present the full paper with the title Prudential Constraint, the Role of Issues. Very welcome, Mr. Trevor. The stage is yours.
Thank you. Can everyone see my screen? Can everyone see it?
Not yet, just a moment.
But it's closed for some reason.
It's not coming. Can you try it again, please? Yes, now we can see.
Okay, thank you. This is your work with Casey Atkinson, who you see there in Happy Road when we could actually meet at the house. That's in San Diego. My paper has three topics: the relation between factors, dimensions, and facts. And I will argue that presidential constraint is best expressed in terms of factors. And factors are assigned to applicable dimensions on the basis of facts. Precedence constraint issues is the second point. And it's issues that constrain cases. So when thinking about precedent, you also think about issues, not cases as a whole. Factors in cases should be structured into issues to avoid irrelevant disputes. And the third topic is presidential constraint only needs factors. We don't need to express presidential constraint in terms of dimensions. Where magnitudes are important, and they are important, we first describe factors on the basis of dimensional facts, and then we apply constraints. So, the history of understanding preferential constraints is a lengthy one. At the very first edition, Edwina Wisdom and Heliassi presented a paper which understood them in terms of dimension. In 1985 onwards, Tendo, with Vincent Elysian and Heliassi, introduced the notion of factors. Then Henry Plachen and Giovanni Starfield showed us how we should write precedents as rules. My contribution in 1999 was to consider the antecedents organised in partial order. And then still ongoing is work in formal characterization of presidential constraints, begun by John Hawking, continued by Adam Bajoni, and summarized by Henry Plachen in a paper this year. So, how do we move from dimensions to factors? The dimensions tell us what needs to be considered in a case. If the dimensions are applicable, it may, not must, it may provide a reason to decide for one of the parties. These reasons are referred as factors. Factors refer the significance of the dimension in the particular case. Sometimes the dimension is either inapplicable or favours one side, in which case it will correspond to one factor. Sometimes it's inapplicable or neutral or favours a side, and the dimension may have more than one factor favouring the side to differentiate different degrees of favour. And sometimes the dimension may be neutral, or it may favour either side. And this dimension has distinct factors to the different sides. Factors should never be related. An action factor may be inapplicable, it may be neutral, it may be a factor for the other side, or a different, stronger or weaker factor to the same side. It's confusing to bundle these very different things under relation. So, moving from the dimension to a factor, let's consider the disclosure dimension. If we have no disclosures at all, the dimension is inapplicable. An insignificant number will lead to no factor. A significant number will lead to a factor, S10 in paper. And in the public domain, we have the very strong co-dependent factor, S27 in paper. So as we move along the dimension, it's first inapplicable, then neutral, then dependent, then strongly dependent. It never favours the plaintiff. Another dimension, security measures, can favour both the plaintiff and the defendant. So we have two distinct factors, S19 and S6. S19 applies if the measures are inadequate. S6 applies if they're adequate. So the dimension is always applicable, but there's a neutral area in which no factor applies. Precedents determine where these switching points occur. S19 is not related to the aspect. It provides a reason for the dependence, but the neutral range does not. So now we consider how can we write precedents as a set of rules. A case can be seen as P union V implies O, where P is the plaintiff factors, V the defendant factors, and O the outcome. So P is the strongest reason assigned to the plaintiff. V is the strongest reason assigned to the defendant. And O will be either plaintiff or defendant, and will show which of these reasons is preferred. So we get three rules: a plaintiff rule, a defendant rule, and a rule expressing a preference between these, depending on the outcome. We can represent this graphically by representing the possible antecedents as two parts rulers. The one on the left to the plaintiff, the one on the right to the defendant. Now a precedent will place an arc between these rulers. So if we have A, B, C, D, E decided to the plaintiff, that shows that A, B, C is preferred to D, E. If B, C, D, E is decided to the defendant, that shows that D is preferred to B, C. Now if we have a U case, it's constrained if it's a reproducible cycle. If we have a case A, B, C, E, then we can put the arrow at either end and there's no cycle. So we can do what we like with second case. However, if we have C, D, E, that's constrained to the defendant. If we were to decide to the plaintiff and prefer C to D, E, we need to use the cycle. We can't have a cycle, and so we have to decide to the defendant. This basic idea has been formalized starting with John 40, going on to Latin with Henry, and finishing this year with Henry Buffett. And there's a list of the papers. The formalization is rigorous, and it shows that all the desirable properties we would want to hold do in fact hold. And it comes in two forms: the results model and the reason model. The results model uses all available factors. No interpretation is needed. Both sides offer their strongest reason. But, unfortunately, it does not in fact constrain many cases. It only supports a certiorari reason. The new case, if it is to be constrained, must be subsumed under the pressure. But we want more than this. We want to be able to argue for cases which, while not subsumed, are constrained by the pressure. Suppose we have a case with security measures, invasive techniques, and disclosures are outside, and a precedent which has similar factors, but also the unique product. We want to say that the use of invasive techniques, such as wiretapping, is sufficient. The actual uniqueness of the product as different. But on the results model, the precedent does not bind because FAC is not there. And this is even though we have a much stronger factor, F6, in the new case. To rectify this, Paul seems to use the reason model. Now the reason model contains only a subset of the available factors. It represents a sufficient reason which, although it's not the strongest reason, is still enough to defeat the opposing reason. The losing rule still has all available facts, and the reason model has the same formal properties as the result model. But there are three problems. How to determine which factors constitute the reason? It's possible that cases are reinterpreted in the light of new decisions, which would disrespect the reason model rather than obeying the result model. And even the results reason model does not constrain enough cases. Irrelevant distinctions are still possible. To find the answers to this problem, we look back to issue-based prediction, which was introduced by Steffi Bruninghouse and Kevin Apple. Whereas Plato was designed to generate arguments, not to predict outcomes. So it didn't matter whether there was constraint or not. The user evaluated the argument. But when Plato was adapted to prediction by Steffi and Kevin, they found that Plato abstained on far too many cases. Plato was considering irrelevant distinctions, like the unique product in the example earlier. So Plato instead considered cases issue by issue rather than as a whole. So IBP instead of cases issue by issue. And this conforms nicely with the IRAC model, widely taught in law schools, where we analyze a case into the issue, the rule governing the issue, not the case as a whole, the application of the rule and the conclusion. So I would argue that thinking in terms of issues rather than cases conforms to this widely used method of reason analysis. The issues form a logical model. They're related logically, and so there's no need to balance them. Once the factors are resolved and the various least nodes are known, then we can infer the conclusion. So what is the role of factors? The role of factors is to determine the legitimacy of the logical model. Each issue is associated with a small group of factors. Factors can relate to more than one issue. And because fewer factors are involved at the issue level, the decision is much more likely to be constrained. There are 8,192 possible decisions for both the defendant and the plaintiff in paper. So imagine the size of the lattice that we have to the past law. However, there are never more than 32 possible antecedents for any issue in IDP. And this enables us to ignore irrelevant distinctions. In the paper, I have a full worked example, but because of the time available, I will jump straight to the last case. The case in question is Boeing, which considers certain manufacture of aircraft windows, cockpit windows. There are a number of relevant precedents: national instruments, television, which is about a PBX, and Bryce, which is about software methodology. And we can see that these cases are, in some respects, similar to Boeing. Boeing is identical to television on the grounds of secrecy, and it's identical to Bryce with respect to the confidential relationship. None of the issues are in voting or opposed. Information valuable simply is accepted, and improper means of info used is established by the use of respective material. So we really want voting to be constrained because television solves the issue of secrecy, and Rice shows or Ratherinson, which Rice followed, shows the issue of confidential relationship. But on both results and reason models, F1 will distinguish federation, and F10 will distinguish Rice and Ratherinson. It's only if we think in terms of issues that we can constrain voting using federation for secrecy and Ratherinson for confidential relationship. And this is what we want. So the argument is that we actually need to incorporate the domain knowledge, the knowledge of the structural cases represented by issues. This is because we want Mason and we want Bowen to be constrained by the precedent in the example. And issues are needed so that the irrelevant differences can be ignored and the cases constrained. Preferences are correctly located at the issue level. And this was recognized by Carl Brankin as long ago as 1991, his paper Losing the Portion Perspective. It was exploited by IBP in ICAO 2003, but it's still currently not exploited in the former House of Presidential Constraint, as represented by Henry paper. Also, for explanation in terms of value, issues allow values of things to be local to issues rather than global, and the global requirement has presented problems in the past for value-based explanation. Now for come on to the third topic, factors of magnitude. Many factors seem to have a continuous favour. The number of disclosures from naught to many thousands. The extent of security measures from minimal to profound. The ease of research engineering. I know that at a glance, but it may take me several years of study and experiment. The length of stay in various domiciles. And all these look like dimensions rather than factors. So how do they work with presidential constraints? This has recently been explored by the usual suspects, John Halsey, Adam McConey, Henry Patton, and even by myself to some extent. The question is, do we need to change our account of presidential constraints to accommodate dimensions? And our answer is no. Presidential constraint uses factors, not dimensions. And the reason for this is reasoning with precedents involves two stages. Firstly, we identify the factors, sometimes termed intermediate precedents in the literature, on the basis of facts. And we find this in jurisprudence, Rossi's taboo paper. We find it in AI and law, Ashley and Bloominghouse. We find it in jurisprudence again with Lars Linger and Overflat. And we find it in AI and law in Patton et al. Identifying constraining precedents by comparing factors is the second stage. we shall visualize in the first place. Consider, for example, disclosures. The number of disclosures is a dimension, ranging from naught to very many. However, the particular number of disclosures in a particular case is a fact. If it's naught, the dimension is impossible, there is no factor. If it's a very small number, there is no factor because it's not significant enough. If there are many, the factor is less 10. And if it's in the public domain, the factor is x87, the very strong dependent factor. And of course, which factor applies may be determined by precedent. I also want to say something about trade-off. Sometimes factors are not independent. Look at the example from Pattern and Sartor used by John Porter. This concerns the same official homicide. It depends on the length of stay and the percentage of income from abroad. The shorter the stay, the bigger the percentage needed. Absence and percentage are, as I mentioned, and in a particular case, the particular absence and the particular percentage are facts. The factor is income sufficient with an absence. And once the factor is realized, we can apply precedential constraint to in terms of facts. As an example, consider the trade-off between income and assets. There's precedent 1 at 66, precedent 2 at 28, and precedent 3 at 2010. Clearly, there's a trade-off because we have the same percentage, but a different factor because of a different length of stay. The precedents show that this area, the area to the northwest of the line, does not apply, and the factor applies northwest, but it does not apply southeast of that line. And so we can fit a line to show the trade-off. Several lines are possible. This one is most generous to the node center. So,
Trevor,
to summarize, there are different roles for precedent.
sorry, Mr. Trevor, 5 more minutes, okay?
I've only got 2 more slides. There are framework precedences identified by Luciani in the Ireland Law 2015. And these tell us what the issues are. And the issues can also come from statutes and documents that the statement before. Then there are restriction precedents, and these determine whether a factor applies on the fact. E.g., 12 months is a short stay, 3 years is a long stay. And we can use either the results or the reason model to factor restriction. Finally, there are traditional precedent precedents. These are the standard sort of precedents found in paper. And these establish which side has to respond to reason. And they may also indicate values. And that's all.
Thank you very much. Well, we won't have time for questions, but in the other panel, when we're going to stream it, then we can have the questions answered, okay?
I think
And
the session was half an hour. Oh, they taking 20 minutes.
sorry,
It's only 10:02. Let's talk starts at 1.
Oh. One question. You want to answer one question then?
No, I'm saying that you have 10 minutes then before the next question.
Okay, so, okay, let's have a
It's
question.
last, I think. That is answered.
So, does your account of factors and dimensions presuppose that for every value of a dimension, it can be determined which side it favors, if any, is from Praken?
The answer is yes, this is presupposed, but it's also the fact of legal decision. When factors linked to use in legal opinion, it is always clear which side is favored. For particular dimensions of fact, such as length of stay, there is sometimes not clear which side is favored. And this is why we turn to the restriction question.
Okay, thank you very much. And now I would like to introduce you to Ms. Paheli Bhattacharya, who will present the full paper with the title Incorporating Domain Knowledge for Extractive Summarization of Legal Case Documents. The stage is yours. Thank you. We can see your slides. You can go on. Thanks. You are muted. Please, your microphone.
Welcome, everyone.
Yes.
I am Paheli Bhattacharya from the Department of Computer Science and Engineering at IIT Kharagpur, India. I will be presenting our work, Incorporating Domain Knowledge for Extractive Summarization of Legal Case Documents. So case documents are inherently very lengthy, free-flowing, unstructured, and dense legal text. Reading and understanding these documents is difficult even for legal experts. Therefore, it is necessary to summarize these case documents. Existing legal IR systems employ attorneys or paralegals to manually write summaries. This incurs a high subscription cost of these systems. This calls for the need of developing automatic summarization systems with the overall objective to improve the legal understanding with lesser dependence upon experts. Now, document summarization is not a new problem. There are methods for news document summarization, scientific article summarization, and so on. Let us see what is different in legal case documents. So on the left, there is a news document. So as we see that it is a very short document and the first paragraph usually summarizes these news documents. Next, there is a snippet of a scientific document, particularly a research article. So these documents are lengthy, but they are segmented into sections and subsections with paragraph headings. On the right, you can see a case document from the Supreme Court of India. These documents are lengthy and it is just a free-flowing text with no section headings. There is something called rhetorical segments in a legal case document, but these segments are often not explicitly mentioned. Let us understand what these rhetorical segments are. So rhetorical segments or labels in a case document are the semantic functions which sentences in a case document plays. So these are usually one of the following labels. Facts, that is the sentences that denote the chronology of events that led to filing the case. There are sentences that denote the legal issues being discussed, so we call them as issue. There are also sentences that denote the ruling or judgments given at the lower courts, so we call them ruling by lower court. Similarly, there are arguments by the contending parties, which we call as argument. Sentences that have citations to established laws by the current case, which we call as the label statute. There are also citations to prior cases, and we call these sentences as precedent. There are sentences that describe the rationale or the reasoning of the court for the final ruling, and we call them as ratio of the decision. And finally, the sentences that give the final judgment or the conclusion of the court. So on the right, this is an illustrative example of how a case document, when the sentences are labeled with each of these rhetorical labels, looks like. So the first approximately four sentences have been labeled as facts. Then some sentences have been labeled as issue. Then one sentence has been labeled as ruling by lower court, and so on. So legal experts have some guidelines on how to summarize a case document. Some of these guidelines from USA and UK are given in the links below. We also discussed with law experts from India, and all of them basically devise the following set of guidelines. So the first one is that each rhetorical segment should be summarized well and have representation in the final summary. This is because often law practitioners or academicians or others wish to read only the summary of particular segments. Example, summary of only the facts or summary of only the ratio. So this following this guideline is important. Second is that each of these segments should also, the important parts of each segment should be present in the summary. For example, from the statute segment, sentences that cite the relevant acts or laws should be present. Now let us see what are the existing methods for case document summarization. So in this work, we are considering extractive text summarization algorithms. So they can be broadly classified into two main families, domain independent and legal domain specific. And under each of these families, there are supervised and unsupervised methods. So under domain-independent supervised methods, we have the state-of-the-art deep learning models like SummerRunner, BERT, and so on. So as these are deep learning models, they require huge amounts of training data, which is expensive to obtain in the legal domain. Also, these methods were developed and evaluated on news documents, which are short. But when we apply them to summarize lengthy case documents, these algorithms become very resource intensive. Coming to unsupervised domain independent methods, so they can actually summarize any document. So they do not incorporate any legal domain specific knowledge. Now coming to the second family of methods, legal domain specific. The first one is the GIST method, which is supervised. As it is a supervised method, it requires large amounts of training data. Also, although it is legal domain specific, but there were no domain specific attributes such as rhetorical labels considered in this algorithm. Finally, there are many legal domain specific unsupervised methods. So case summarizer is one, but this algorithm does not assume the presence of any rhetorical role. So they rank sentences based on some importance score, but this score is based on a heuristic where there is no parameter from the rhetorical role perspective. The other three methods, LETSUM, KMM, and MMR, uses the rhetorical information, but just to display the summary in a templatic format. It does not use rhetorical information in estimating the importance of sentences for generating the summary. For instance, LETSUM uses TF-IDF to measure the importance of the sentences. In short, there are two main drawbacks of the prior works. The first one is that the existing algorithms do not incorporate legal domain specific knowledge systematically. While the supervised methods are expected to learn these rules automatically, there are two disadvantages. First is that there is a scarcity of expert written summaries in large amounts to be used as training data. Secondly, summary requirement may vary for different stakeholders. For example, a journalist who is briefing a case wants a different type of a summary. Maybe he or she wants the ratio to be summarized well, whereas a law practitioner may want the facts and arguments to be summarized well. So it is not practical to gather huge amounts of training data to cater to each type of the stakeholders. So in this work, we propose del sum, which is an unsupervised domain adaptive extractive legal summarization algorithm. Del sum works in an optimization framework to incorporate legal domain knowledge into an objective function with constraints, and this objective function is maximized using integer linear programming. So del sum takes as input a document where each sentence is labeled with a rhetorical role and the desired length of the summary in number of words. Let us call that L. So given these two inputs, del sum produces a summary of at most L words. So the optimization framework of del sum has two main components. The first is the informativeness of a sentence. It measures the amount of important information contained in a sentence. We assume that domain experts will define how to estimate the informativeness of a sentence. The second one is the content words, that is the words that signify domain-specific vocabulary. With each content word is a score which shows how important that content word is. Again, we assume that domain experts will define what the content words are and how the scores are defined. Del sum produces a summary that maximizes the following objective function. That is, it tries to maximize the inclusion of informative sentences and the number of important content words, subject to constraints that the summary length should not exceed L words. And there are other constraints, so please refer to our paper for more details on this. Now let us see how the legal expert guidelines can be incorporated into del sum. In this work, we considered summarizing Indian Supreme Court case documents, and our experts are the senior law students and a professor from the Rajiv Gandhi School of Intellectual Property Law, which is a reputed law school in India. So the first guideline they gave us is that in general, the summary should contain representations from all segments of a case document, and the relative importance of segments in the summary should be as follows. So first and foremost are the final judgment and the issue. Next comes the facts. Then the statutes, precedents, and ratio are of approximately same weightage. And then comes arguments, and the other label, ruling by lower court, is not so important to be included in the summary and may as well be discarded. So we formalize this in del sum as follows. So we have a variable called weight k, which defines the weights of each of these segments, and we assign the highest weight to the segment's final judgment and issue. And for the other segments, the weights decrease exponentially or linearly. We may as well assign discrete scores to or discrete weights to each of these segments. The second guideline is that the segment's final judgment and issue are exceptionally important in the summary. The segments are usually very short, and so they should be included completely in the summary. And to ensure a balanced representation, a minimum of 2 sentences from the other segments should be included. We formalize this guideline in del sum as follows. We have a variable NOS, or number of sentences for a segment K, defined as follows, that if the segment is final judgment or issue, then all of the sentences should be taken. Otherwise, a minimum of 2 sentences should be taken. The third guideline is that the important sentences should be decided based on which segment that sentence belongs to, and also other factors. If the sentence is from fact, then we will take the weight of the segment fact and also the inverse of the position of the sentence. If the sentences are from the segment statute, then we will see if the sentence contains citations to an act. So for that, we keep an indicator variable AI for statute, and this AI is 1 if there is a citation to an act, otherwise 0. Similarly, for precedents, we see if the sentences contain citations to prior cases. And for the segment ratio, the guideline is that the sentences appearing at the end of the document and those that discuss relevant statutes and precedents are important. So to formalize this, we assign the weight of the segment ratio, that is weight K, the position of the sentence, and whether there is a mention of statute or a precedent. The final guideline is that the summary must contain sentences that give important details of the case, including acts and sections of acts that were referred, names of people and places, and also sentences containing specific legal keywords are important. So we formalize this by having three types of content words. The first one is the acts or sections of acts, to which we assign a score of 5. The second type of content words are the keywords from a legal dictionary, to which we assign a score of 3. And then we have the noun phrases, to which we assign a score of 1. Now, let us see the dataset and experimental details of this paper. So in this work, we considered 50 Indian Supreme Court case documents, where each sentence of a document was labeled with one of the 8 rhetorical segments. So this dataset is available from our prior work. Each of these 50 documents had gold standard summaries written by 2 senior law students from the Rajiv Gandhi School of Law. They wrote segment-wise summaries and they combined ratio and precedent into one segment analysis. The summary lengths were approximately 30% of the original document, and we had 2 sets of summaries. The metrics, the evaluation metrics we considered are the rule scores between the gold standard summaries and the algorithmic summaries. We considered several baselines. So from the 4 families, which I described in one of my earlier slides. So from the unsupervised family, we have domain independent as well as legal domain specific methods. And from supervised also, we have domain independent and domain specific methods. So the supervised methods were trained on 7,100 document summary pairs. So details of this training mechanism can be found in our paper. So now let's see the results of the approaches and also some analysis. So this table shows the Rouge 2 and Rouge L recall and F scores. So out of all the domain specific methods, both supervised and unsupervised, we see that DELSUM performs the best for all the measures. While comparing with supervised domain-independent methods, we see that DELSUM outperforms both SummerRunner and BERTSUM. The difference with SummerRunner in Rouge 2 is not statistically significant. Note that DELSUM is unsupervised, whereas SummerRunner and BERTSUM were trained on 7,100 documents. Next, we do a segment-wise performance evaluation. So in this table are the segment-wise Rouge L F scores of all the methods. So values in red underlined are the ones which are less than 0.3, and the best value for each segment is in green bold. So as one can observe that DELSUM performs best in 3 out of the 6 segments. And overall, it achieves a balanced representation of all the segments in the summary. Especially, DELSUM performs better for final judgment and issue, which are the most important segments in the summary. These are also the shortest segments. Other algorithms with no domain knowledge completely misses these segments. So we have more analysis and intuitions in the paper. So till now, we have been using expert-assigned rhetorical role labels for summarization. But in a practical scenario, it is not possible that sentences in the input case documents will be labeled by the experts. So in this experiment, we use a state-of-the-art model to first rhetorically label the documents and then feed them to DELSUM. So the results show that the performance does not drop much, even when the rhetorical labels are around 80% accurate. Let us now give a brief note on the generalizability of DELSUM. So DELSUM is generalizable to documents from different jurisdictions as well as different stakeholders like law practitioners, students, etc. So this is because DELSUM is quite customizable, and this is through the different parameters like the segments and weights of the segments can be defined by whoever is using this algorithm. Also, the minimum number of sentences from each segment can be given as input. Finally, the content words and what will be the weight of these content words can be decided by the different stakeholders. DELSUM can be modified to include various guidelines. For example, if a stakeholder or jurisdiction wants the summary to have facts and final judgment, then WK and NOSK should be kept higher for K is equal to facts and final judgment. Similarly, if there is a use case that the statute sentences should be more than the sentences with noun phrases, then the score of the statute words can be kept higher than the score of the noun phrases. So to conclude, in this work, we propose DELSUM that can efficiently encode domain knowledge for extractive summarization of legal case documents. We show that it is necessary because important segments like final judgment and issue gets missed in otherwise unguided algorithms. DELSUM achieves a balanced representation and it can also handle redundancy efficiently. It is also generalizable to different jurisdiction and stakeholders. So as a future work, we plan to explore how these otherwise hand-tuned parameters of DELSUM can be automatically derived, how the weights can be automatically derived. So our implementation of DELSUM is publicly available. So I would like to conclude by acknowledging the law experts from the Rajiv Gandhi School of Intellectual Property Law, India, TCS for their fellowship, the Mirror EU project, and Complex Networks Research Group, IIT Kharagpur. Thank you, and I can take questions now.
Thank you very much, Paheli. Well, we have one question for you from Marcela Lopez. Do you have any hypothesis that could explain why the unsupervised algorithm you developed outperformed the supervised learning models?
Yeah, okay. So the supervised training algorithms depend on the kind of data they are given to summarize. I mean, the learning process depends on what kind of data they are given. So maybe the summaries which we collected from our website, maybe their quality did not adhere to the guidelines of what the legal experts tell us. So maybe that is a reason why the supervised methods did not perform well.
Okay, thank you very much. Do you have any other considerations or few words to finish it?
No, it's fine. So thank you everyone for your attention, and please go through our paper, and if you have any questions, you can get back to the authors, me and the other authors. Thank you.
Okay, thank you very much. Well, now we will have 1 hour break, and those who want to meet other participants and exchange experience can access the Gather Town platform for a networking moment. The link is at the OpenFi platform. Thank you very much and see you soon. Bye-bye.
5, 4, 3, 2, 1. Hello, everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Roberto Bornhausen, and I'm a member of the local organizing committee from University of São Paulo. And this is the third panel of the second day of the event. I'm sorry about the noise here. We have this online conference with real problems. But first, I would like to present our sponsors of this panel. So first, I would like to present our platinum sponsor, Jus Brasil, which is currently the #1 law and government website worldwide with 28 million unique users each month that make high-value legal information super easy and quick to access, thus saving its users time and providing substance for their case strategies and insights. And also, I would like to present our hospital, Albert Einstein Israeli Hospital, platinum sponsor, which is the best known health units in Brazil and Latin America for the quality of care and the equipment and medical specialties available to treat main types of pathologies. The hospital is reference in treatments with state-of-the-art technology and humanized care, expanding its borders with social responsibility actions, teaching and research activities. Now, I'd like to present our speakers of this panel, which are first, Professor Juliano Maranhão, and second, Mr. Wachara. So now I'll pass the word to Professor Juliano Maranhão. Please, the floor is yours, Professor Juliano.
Thank you very much, Roberto, and good afternoon to all, or depends on the time zone. So hello to everyone. I'm going to present our paper now. I'm going to share the screen. Is it visible for everybody? Okay. So the paper is, the title of the paper is A Dynamic Model for Balancing Values. It's a joint work by myself, Juliano Maranhão, representing the University of São Paulo Law School, the Center for AI at the University of São Paulo, and the Logarithm Institute. And also Edelcio Gonçalves de Souza, a co-author, a colleague at the University of São Paulo and Logarithm, and Giovanni Sartor from the University of Bologna and the European University Institute. Our goal, our short-run goal in this paper is to model reasoning with rules and values. There is an apparent consensus that applying the law is not limited to applying rules, but also to apply rules in consideration of underlying values. There are at least 3 ways in which rules and values are interconnected in legal adjudication and legal reasoning. The first one is that values are a critical framework for assessing the merits of positive laws. That is, values are used as an assessment to the extent to which the rules meet some standards of justice and fairness, and therefore this may affect the validity of rules. There are different legal theories to approach what is the particular relation between law and morality and with respect to the validity of rules. The second way that values are relevant in the application of rules is it regards interpretation. So in interpretation, when the interpreter selects alternative meanings to legal terms, it considers underlying values and teleology, that is, the extent to which the rule, the meaning which is ascribed to the rule, better promotes or demotes relevant values of the community. And the third way in which values and rules are interrelated is regards the proportionality reasoning in constitutional and human rights assessment. That is, if there is an infringement of constitutional right, this infringement is assessed with respect to advantages regarding other constitutional rights and fundamental rights and values, and it's assessed if there is a better trade-off in this conflict between constitutional values. So also here there is a choice between the underlying morality, public policies, or fundamental rights, which are relevant for the application of rules. So since these values are also relevant for interpretation, the long-run goal of this research is to contribute for the tenet of making the law computable, given that to providing logical models to represent law in a computable way. So this research is connected with, is a continuum with respect to previous research. The first one presented at ICAU 2017, where we discussed a logical architecture for dynamic of legal interpretation. We were concerned with the interplay between changing rules and changing meaning ascription and changing values which are underlying those rules. Then in Dion 2018, a paper with Edelcio Souza about the contraction of constitutional and constitutive and regulative rules. And then Maranhão and Sartor in ICAU 2019, we assessed how the balance of values may affect and change legal rules. And in Dion 2020, a paper with Sartor called Interpretive Normative Systems, we assessed different legal theories regarding the relation between law and morality. As a running example to our model, we have used the Riley versus California case judged by the US Supreme Court in 2014. According to the law at the time, police officers were permitted to access the content of any item found with the arrestee in an arrest. And then a new question was raised by this case, which was, is it permitted to access also the digital content of the arrestee's mobile phone? And the answer by the Supreme Court at this time was no, that is, the police must obtain warrant to search cell phones. And this was based on a consideration of underlying values. Specifically, it was argued that in this case, there is a significant impact on the privacy of the arrestee if the digital content of the mobile phone is accessed. So in the balance of values regarding safety and privacy, in this case, privacy would outweigh safety, and therefore it should be forbidden to access this particular property item of the arrestee. So we would like to model it, and in particular to understand how is this balance between competing values and how they affect legal interpretation. But we are going to focus on arguments about values which are demoted against values which are promoted by the action at stake. I'm not going into the details of the formalism.
This meeting is being recorded.
I'm not going to the details of the formalism, but I'm trying to show how the model works using the example given by Riley versus California. So the whole game here in this model is to compare those values which are demoted against the values which are promoted by the action at stake, given a certain constellation of factors. So we divide the values which are relevant within those which are demoted and those which are promoted, and use an impact function to assess whether the action impacts the demotion or the promotion of a given value, and also use factors that may intensify or attenuate the impact of such values. So the idea is that we compare the proportional impact on values with the proportional analogous. And if the demoted values beat the promoted values, then we have a reason to forbid the action at stake. Otherwise, we have a reason, if the promoted values are stronger than the demoted values, then we have, or equal to the demoted values, we have a reason to permit the action given that constellation of factors. And so there is also a connection with argumentation with this approach, since we know that the argument bringing values which are relevant and has some hierarchy within the field of underlying values to rules, and then arguing that actions may impact those values, are arguments to the fact that there is a reason to forbid a certain action, or there is a reason to permit this action. So we want to also to bring this argumentative dimension, but we model it by means of change functions. So let me give an example of the additive model that we have used. We have await functions taking values to the interval of real numbers 0 to 1, and they are going to represent dimensions of relative importance of these values and a hierarchy between the values at stake. And then an impact functions that take factors and values and represent the impact, an impact function for each action, and it represents the impact of the action in the value, and actually the influence that factors may have on the impact of the action on such values. And this impact may be positive. This influence of the factors on the impact of the action on values may be positive, or it may be negative. If it is positive, we call the factor an intensifier. And if it's negative, we call the factor attenuator. Of course, one may argue that there is some arbitrary choice between the interval of real numbers that we assign to weight of functions and to impact of factors or of actions on the values. But actually, this is just a model to try to represent reasoning with dimensions and magnitudes. So any scale may be used to represent this impact. It can be an interval of 3 points, for instance, low, medium, and high. It could be of 5 points, low, medium, high, and high, and so on and so forth. It depends on each model of representation that one would like to use. But the fact is that there is a rationality using this dimension, and that's what we want to capture. So here in the example, if we consider the impact of the action on a certain value, we call it a baseline impact if there is no factors to be considered. So in this case, in the Rilo versus California case, we are concerned with the impact of the action of accessing an item which is found with the RST. So accessing any item has a baseline impact of 0.4 on privacy, and privacy has some weight. The proportional impact is the product of the impact and the weight of the value. So here we have, in a baseline situation where there is no factor considered, we know that we have that the privacy, the impact on privacy of the action of accessing outweighs the impact on safety, since there is no no charge against the individual, then the result is that the demotion of values is stronger than the promotion, so the action is forbidden to access. But we may consider intensifier factors. For instance, the factor that there is an arrest intensify the impacts on safety by the action of accessing. And therefore, if you consider the product with the relative importance of safety, we will have that the balance shifts, now making the action permitted in the case of an arrest. And if we move now for a consideration of property rights, the factor that there is a property item, then this increases the impact now on the demotion of property rights, but it's not sufficient yet to beat the promoted values. And therefore, it is still permitted to access the items if there is an arrest and it's a property item. However, if we consider a mobile phone, then this is another intensifier that intensify, as the Supreme Court said, significantly the impact on privacy. And this makes that the aggregate impacts on the demoted values becomes stronger than the aggregate impacts on the promoted values, which means that if there is an arrest, it is a property item, but it is a mobile phone, then the balance says that there is a reason to forbid the action of accessing the digital content of this mobile phone. But factors may have an attenuating influence on the impact of action on values. For instance, if we consider that the mobile phone is not a personal one, but is a professional one where only professional content is allowed, then this would attenuate the impact on privacy and may shift the balance again for an authorization to access the content if the mobile phone is not personal. So that's how the game is played within the additive model. But our main concern and contribution in this paper was to describe how the shifts of balance occur if we add factors, or if we contract factors, or if we add values, or if we delete values from the model to be considered. And this may reflect argumentation so that there is a factor to the fact that there is a factor that was not considered, or to the fact that there is a factor that actually is not present, and therefore this will change and shift the resulting deontic status of the action at stake. So the goal was then to describe balance shifts by changing either the set of factors or by changing the set of values. If in this game we are concerned about who's going to win, is it going to be the demoted values or the promoted values in the balance? So if we consider a situation where the demoted values beats the promoted values, it makes the action forbidden, and we want to know now how this balance may be shifted. There are two ways, basically, in which this value may be shifted by the addition of new factors. It may be a strengthening of the opponent, that is, a strengthening of the promoted values, and we may strengthen the opponent by adding intensifying factors to it. We called it a factor rebutting expansion function. Rebutting because it looks like a rebutting in structural argumentation, since we're going to come with a new opponent to the argument and strengthen the opponent. So for factor rebutting expansion function, you add factors which intensify the impact of the action on the promoted values. But it may be an undercutting if we weaken the winner. And we do that by adding attenuating factors. Now, we also may shift the balance by contraction, by deleting some factors. So if we delete factors which attenuate the impact of the action on the promoted values, we have a factor rebooting contraction function, because we are deleting attenuators of the opponent. So we make the opponent stronger. But we may also delete intensifiers of the winner. So we may weaken the winner. This would be the case of a factor undercutting contraction function. So let me show how this could work in the example. Suppose we have this previous argument position, and then we have as values promoted privacy, and values demoted privacy and promoted safety. And now we are going to add a new factor by a rebooting expansion function. This new factor increased the strength of the promoted values, and therefore it beated the previous argument position where the action was forbidden because the demoted values were stronger than the promoted values. Now we add that is the context of an arrest, and therefore this will activate the value of safety, and therefore it shifts the balance to a permission of the leading to a permission of the action in the context of an arrest. Now, to represent a contraction, let us suppose then that we have this as our previous position, and we delete the arrest and safety. So we had before that the promotion of values beated the demotion of values, making the action permitted. But now, if we deleted the arrest and say that the arrest was invalid, or that there was not an arrest as an argument, this will shift again the balance, making thus the action forbidden. And this would be an undercutting contraction function, since it weakens the winner by deleting an intensifier. Now, suppose we have this as an original argument position, where we have that the action is forbidden because it's an arrest of a property item, in particular of a mobile phone, and we have that the aggregate impact of the values demoted are stronger than the values promoted. Now, if we expand the set of factors by the factor that is not a personal item, this will attenuate the aggregate impact on the demotion of values, weakening the demotion of values, and making it weaker than the promotion of safety. This will then have an effect of shifting the balance, and since it is an addition of an attenuator on the winner side, we call it an undercutting expansion function. Now, if we consider this as the original position, and we want to delete the factor in question, then we would have that the attenuating factor of the opponent is deleted, and therefore this is a factor rebooting contraction function that shifts again the balance. I think we are ahead of the time. So with respect to with respect to the shifting of balance, we may also have the shift concerning the set of values. if we add values or if we contract or delete values, this may also lead to a shift of the balance, changing the reasons for a prohibition to reasons for a permission. This shift may be caused by a value rebutting expansion function. And what is that? If you add values promoted by the influence of intensifying factors. So if you strengthen the opponent by adding values, but you may also weaken the winner by adding values. And this will be a value undercutting expansion function. We may also have the effect of shifting balance if we use a value rebutting contraction function that is to delete an attenuating factor from, to delete a value which is promoted by the influence of an attenuating factor, or otherwise, if we have a value undercutting contraction function, if we delete values that are demoted by the influence of intensifying factors. So let me give, just to finish, an example of adding a value. Suppose we have this as an original position, and in this position, the promotion of safety beats the demotion of property rights. But then if we add into consideration the value of privacy, and we know that there is a baseline impact on privacy, then this will shift the balance by expanding the set of demoted values, by making them, since you strengthen the opponent, this is a value rebutting expansion function. And you may have an undercutting contraction function when you delete the corresponding value. And so on and so forth. These are the moves that may be described. In the paper, we have made a formal description of these functions in an AGM style. And the idea then is now to raise your interest to the paper by showing how it works in the model, but we didn't enter into the technical details. If you would like to know these technical details and the construction of these functions, please visit our paper in the proceedings. And I thank you very much for your attention.
Professor Juliano, thank you very much for your paper, your presentation. Now, I would like to pose a question from the audience. Mr. Rafael Saravalli has the following question to your paper. How could this model proposed by you represent analog reasoning?
Well, it is possible to represent analogy in this model. For instance, if you have, let us see that it's forbidden to, sexual abuse is forbidden, but it is permitted in the case of a pregnancy which is a resultant. Let us take an example of abortion. So it's forbidden to provoke abortion, but if this is the case of sexual abuse, then it's permitted to perform the abortion. Then this is the case because it impacts in this case, present this fact, there is an impact in woman dignities that outweighs the life of fetus. So we may use an analogy in this model by saying, for instance, that the case of an encephalic fetus is analog to the case of sexual abuse, because carrying the pregnancy in this case means significant suffering for the pregnant. So in this case, if you consider that this factor is an analog with respect to the impact on values, then we would expect to have the same solution by saying that it is permitted in this case, to perform an abortion. So we may use analogies by saying, if this factor is similar with respect to impact on a similar value, then the solution should be the same. So it's possible to accommodate analogical reasoning within this model.
Thank you very much, Professor Juliano. Now you have the floor for 1 minute for final words.
No, just like to invite you again to read the paper, and we still are investigating this issue. One of our goals is in future work to explore situations where we compare different actions, because this model is applying to one action at a time. So all the functions are indexed to a particularly given action, but now we would like to compare different actions in terms of their impact on aggregate impact on values. So thank you very much.
Thank you, Professor Juliano. Thank you, Professor Adelcio as well. Now, I would like to present again for the second time today, directly from Japan, Mr. Wachara Fungwachara Korni, with the replay of the paper on semantics-based minimal revision for legal reasoning. Mr. Wachara will replay his video from this morning, and then he will be available to answer questions from the audience.
Greetings to you all. So this work is a work that I worked with Assistant Professor Kaneji Shima and Professor Ken Sato, and we are from NII and Sokendai in Tokyo, Japan. So this presentation is divided into 4 sections and shown here. So let's go, let me give some background of this work. So in this work, we consider the problem that the literal interpretation of statutes may lead to counterintuitive consequences. Which are the counterintuitive consequences are the consequences that do not meet the social expectation and the consequence occurs since the social expectation is evolved or exceptional cases happen unexpectedly in real life. So this kind of consequence cause absurdity, strange behaviors, or leads to public interest if the consequence were not properly handled. So judges, especially in high courts, may handle this kind of consequence by considering the exceptional situation of the case and make the legal judgment known as the case law that divides the interpretation of the statute to handle the exceptional situation. So in this work, we consider minimal revision. This is one common criterion from the standard revision theory. We reset it to adjust theories as little as possible. So minimal revision can be divided into 2 main types. The first type, as we call syntax-based minimal revision, is to keep the set of rules as close as possible to the original one. So this type of minimal revision is independent from the facts of the case. And the second type is the semantics-based minimal revision, which is to minimize the change of the set of conclusions obtained from the theory. So this type of minimal revision depends on the facts of the case, since different facts give different sets of conclusions. So although the syntax-based minimal revision is benefit from the independence of the facts of the case, we argue that the semantics-based is more preferable in legal listening. Since legal listening is a hybrid listening between rule-based listening and case-based listening. So therefore, we propose here one kind of semantic-based minimal revision called a dominant-based minimal revision. So this solves some problems in attempting to develop a semantic-based minimal revision. So let me give some settings of this work. So in this work, we consider a normal logic program also known as a log program for representing the schedule as its many previous works. So a normal logic program, or hereafter a program in short, is a set of rules in the form of head, if, the bodies, where the body is divided into two parts. With the first part is the positive body, and the second part is the negative body containing the negations, where the negations here, it shall be interpreted as negation as failure. So in civil litigation, a judge would make correspondence between factual situation in the case and factual concept in schedules. Then the judge would conclude a legal decision based on the schedules. So to reflect this civil litigation, we determine propositions into two types. The first type is rule proposition, and the second type is fact proposition. So the fact domain is a set of all fact propositions in the language, and the case is a subset of the fact domain. So we define the fact base and the rule base as shown, and we get that the answer set is the set of conclusion from the union of the fact base FB with a rule base URB. So this represents the literal interpretation of the statute, which is represented as RB when applying in a particular case that's represented by FB. So we denote a proposition P is in the answer set of FB union RB by FB union RB derives P. So exceptional case is the case that the judge disagrees with the literal interpretation in the case, and the judge introduced a new factual concept to distinguish the case as exceptional. So we formalize the agree and disagree as follows, saying that FB1, the fact that FB1 union with the rule base RB1 agrees with the fact that FB2 union with the rule base RB2 on some proposition P if is derived in the same, they derive in the same manner, or they do not derive P in the same manner. So otherwise we say that if B1 union RB1 disagrees with B2 union RB2 on P. So now we can formalize a counterintuitive consequence resolution task, or CCR task in short, which is the tuple of RB, FBE, and P, where RB is a rule-based representing statutes, and FBE is a fact-based representing exceptional case, which contain at least one new fact proposition not occurring in RB. So P is a rule proposition representing the considered counterintuitive consequence. And we call some rule-based RB prime is as a resolution to the CCR task if FBE union RB prime disagrees with FBE union RB on P. So this implies the counterintuitive consequence is resolved, the P1. So let's state with the example. Let the fact domain be the set of ABC, and this is the simple rule base of P if A, Q if P if Q, Q if A, Q and Q if B. So suppose P here is a counterintuitive consequence, and we apply this exceptional from applying this rule base in an exceptional case represented by the set of AC. Then we get that there are many resolutions to this CCR task. One is to add the exception not R in the first rule like this, and then we add the rule R if C. And then the second way is to add not R in the second rule, and we add the rule R if C. both are the resolution to the CCR task. So we use the concept of cockpit in digital debugging to specify which rule should be an exception, which is not to be put in. So for example, we say that RB2 aims to resolve the cockpit P because it adds in not R in the supporting rule of P, while RB3 it aims to resolve the cockpit Q since it's added in the supporting rule of Q. So we consist this kind of semantics of a rule base and the semantics minimarization. So we consider semantics of a rule base RB as a set of all pairs between the possible fact base FB and the answer set of FB union RB. So for example, this is RB1 and RB2 from previous slides. So we get this kind of possible fact base that interpolate from the fact domain of ABC. And then we have the answer set of corresponding to the rule base RB1 and the rule base RB2 as shown here. So we get that the symmetric difference of this answer set would contain R if the fact base contains C, because the new rule is R if C. Therefore, we have R in all such fact base, and the set of C, the set of AC, the set of BC, and the fact base of ABC. So to eliminate this kind of effect, we consider partial symmetric difference with respect to some set. So as per the set of P here. So we create the intersection between the given set and the symmetric difference. Then we get that there are three rows. In this example, there are three rows such that it contains the set of P as this partial symmetric difference. So for another example, as we have the RB3 that add not R in the second rule instead of the first rule. We get that in the same manner, we get the partial symmetric difference only in the row that's correspond to the fact base FB as AC. So we can see that RB3, this kind of RB3 has a smaller change than RB2 from the original rule base RB1 with respect to the set of P. And it seems that RB3 is a symmetric based minimal revision with respect to P, the set of P among all the solutions to the CCR task. So if we would like to have the smaller change than this RB3, we need to make this law to be empty set. But to make such thing, it make that it's not a resolution to the exceptional case of AC anymore. So we can consider RB3 as a semantic base, it seems. However, there are two problems in such definitions of minimal revision. First, it is exhaustive to interpolate the answer set for each fact base. And the minimal revision is broken when the fact domain is extended. So let's make it with the example that suppose we extend the fact domain in the previous example to the set of A, B, C, D. Then we get these following tables. And we get that the row that have non-empty set within the set of P in this case contains in the row corresponding to the fact base AC and also ACD. So it's guys that there exists a resolution, some resolution RB prime that have smaller change than RB3 instead that such RB prime would have no change. So this row will be empty set as it then. However, we consider such resolution RB prime to be too specific because we need to change two times. The first one is to change corresponding to AC, and we need to reverse back in the fact base ACD. So to solve this problem, we consider that each fact base has a corresponding specific rule base and dominant rule base with respect to the considered constraints. So we say some subset SR of ARB is of whole root base RB is specific to the fact base FB with respect to the whole root base RB and on position P. If SR is a minimal subset in the sense of set inclusion, such that if we union with such SR with the given FB is agrees on the union the whole root base RB with such FB on P, and no intermediate root base SR prime such that is in between SR and RB, and FB union SR prime disagree with FB union SR on P. So specific root base might not be unique, and if we have some specific root base set of specific root base, we say that a dominant root base is a set of specific root base, but removing the negative body of the root. So let me illustrate with the example that we have the root base RB1 and RB2 as previously illustrated, and we say that the dominant difference of the dominant base semantics is considered by the pair of dominant root base changes, regardless how many fact base would dominant root base are changed in that way. So for the example of RB1 and RB2, we get that there are 3 patterns that have been changed. So as shown here, the first these 3 rows. So for another example that we have RB3, where the second not R is added in the second row, we get that they have only 2 patterns that have changed. One is the pattern of the corresponding to the fact base AC, and another is correspond to the fact base ABC. So this pattern also although it was same when we extend the fact domain. So if we extend it to ABCD, we will have the same pattern here, but we does not count how the fact base is, but only count the patterns, so that this kind of difference is independent from the extension of the fact domain. So to obtain this kind of dominant root base, one way is to extend the body of the new rule so that it influences the dominant root base as least as possible. For example, if we suppose we would like P is as a culprit, and we add not R in the first rule, then the way to make minimal revision is to extend AC the new rule as R if AC instead of R if C. Then we get only 2 revision that only 2 changes that in the rows.
Mr. Bhattacharya, 5 more minutes, please.
Right. So given a CCR task, let me illustrate with the working example that given a CCR task of JRB1, JRB1, which is the rule base that represent Japanese Civil Code Article 612, and this talk about the cancellation of the lease contract due to the subleasing without permission. And this to prove that the cancellation due to sublease, we need to prove 4 requisites. The first one is the lease contract must be effective. The second one is the sublease contract must be effective, and the third one is the listing use, and finally the cancellation is manifested. And this one exception, that is sublease has been approved before cancellation, then cancellation due to sublease shall not do that. So this effective contract has one rule R2, but the effective sublease contract suppose that there are 2 rules, R3 and R4. Yeah, so there are 2 types of effective sublease contract. And this one exception rule about the approval of sublease here in R5. And we have the exceptional case that have this kind of 6 facts, which literally make cancellation due to service to be valid. But the judge indicates the facts about non-destruction of confidence as an extra fact, and would like that and did not intend that cancellation due to sublease to be valid in this case. So the cancellation due to sublease is our counterintuitive consequence here. So one way to revise to have the solution of this is to add new exception, while the new exception is derived from non-destruction of confidence, the extra facts. However, we get that this JRB2 will make a necessary change to the dominant rule base of the relevant case that with the broad case of sublease, a second kind of sublease, since it will execute the exception as shown in this table. So another solution is as shown that instead we have the new rule of exception that derive from these three conditions. So when compile this kind of rule base and fact base and execute this dominant rule base, we get that the dominant rule base of this kind of this JRB2 does not make unnecessary change occurring in JRB2. JRB2 is actually a dominant base minimal revision. Usually, this new rule for the new exception box other type of sublease and allows only the type of sublease that relevant to the present case. So let me have the conclude of this presentation that in this work we propose a dominant-based minimal revision, which is a kind of semantics-based minimal revision. And this solves two problems in attempt to develop semantics-based minimal revision. One is this is not required to calculate the set of all conclusions for each case and is unaffected by the fact domain extension. And in further, we would like to develop effective algorithm for finding such minimal revision and make applications for other type of legal representation and other type of revisions and application for the case where the revision impacts several rules. So we hope that this minimal revision may lead to impact analysis in legal formalisms and may contribute to improving coherence in law. So this is the end of the presentation. Thank you very much for your attention. I look forward for the question. Thank you very much.
Thank you, Mr.
Mr. Wachara, thank you very much for your replay. Now we have a few questions from the audience, okay? The first one from Mrs. Judith Garcia. How can we define a counterintuitive consequence?
Right. Thank you very much for the questions. So in this setting, in this work, we consider the setting called the legal debugging, which we assume that a legal listening system derives consequence from the literal interpretation. And user works as an oracle query of an unknown set of intended interpretation. And we determine a counterintuitive consequence is a consequence in the symmetric difference between consequence of literal interpretation from the system and the consequence of the intended interpretation from the user. So that is the brief definition of counterintuitive consequence. And we call such thing legal debugging because we make iterations to ask the user whether the related consequence are counterintuitive consequence. And this is how we determine the things that are called the culprit, which is the root, which we determine as a root of the counterintuitive consequence, and that we put the exception in. So this is the definitions of counterintuitive consequence and the culprit. Thank you very much.
Thank you very much, Mr. Wachara. Now, are you able to answer a second question?
Yes, so I have the second question about
can you read it for us, or would you like me to read for you?
So the second question that I have is, does the model proposed in the paper consider only counterintuitive consequence that arise from the literal interpretation of the rules, and also those that arise from other methods of legal interpretation? So if the answer is negative, is it possible to build a model capable of considering other methods of legal interpretation? So thank you very much for the question. It's interesting. First, we assume that the system, although we assume that the system represents a literal interpretation of the rules, but that is the primary presumption. However, if the user represent the system as any, it can represent the system in any application, any kind of interpretation, so that such interpretation that reflects from the system, it shall be determined as one that we would like to say that it is original interpretation, and the difference between intended one from the user and the one that obtained from the system is counted in this kind of counterintuitive consequence also. So this is one way to formalize this kind of interpretation that we have, although it's not a literal interpretation, but it's one that had been represented in the rule as a rule base, and the one that we have intended in interpretation in the user's mind.
Thank you very much, Mr. Wachara. Now you have
very much.
1 minute for final words.
So thank you very much for your questions and comments. And I hope that I have received many recommended papers also. So thank you for that. And I would that is very interesting, and I will further read this paper theory. So thoroughly. So thank you very much.
Thank you very much, Professor Juliano. Thank you very much, Wachara. Right next, we are going to have our keynote speaker of the day, Joe Cohen. And in a few moments, Mr. Aden will be here with us presenting Mr. Joe Cohen. Thank you very much.
Welcome to the first keynote speaker session. First, I'd like to thank our sponsors, our platinum sponsors, Jus Brazil and the Albert Einstein Israeli Hospital. And then I'd also like to thank our gold sponsors, Logarithm and Legal Code. We have today our first keynote speaker, Joe Cohen. I'll say a few words about him, and then I'll say a few words about the firm that he's working at. Joe leads the innovation team at Dentons, UK, Ireland, and Middle East region. So it's a specific region that he covers. This includes responsibility for legal tech pilot projects and implementations, as well as other innovation culture initiatives, such as innovation training and design thinking, which is a growing area for legal tech. Prior to this, Joe worked as a non-lawyer. I'm not really sure what a non-lawyer is, but it's an interesting role. He held innovation positions at Linklaters, as well as Slaughter and May. And before that, he was a technology consultant for Deloitte. So Joe has a lot of experience at a lot of large law firms under his belt. I'll say just a few words about Deloitte, about Dentons, about Dentons. Dentons is the world's fifth largest law firm by revenue, almost 3 billion USDA gross revenue in fiscal year 2019, so large in terms of cash flow. In 2015, it was the largest law firm in the world in terms of numbers of lawyers, and it has the most offices of any law firm in the world. It operates in 77 countries and has 190 offices. That's 2015 numbers. We don't know exactly what it is now. So this is, globe-spanning large firm, and Joe is key to that. Joe, thanks very much for accepting the invitation to speak. Joe will speak about iRobot, how to use robotic process automation to automate certain legal work, and we look forward to your words. Thank you very much.
Perfect, thank you, Adam. Okay, I'm just going to share my screen, and then we'll get going. Okay, so yeah, thanks, Adam. So I'm Joe Cohen, I'm the innovation lead for Dentons UK, Ireland, Middle East, as I was saying. And today we're going to be talking about robotic process automation. We'll start off by defining what that is, and henceforth I'm going to define that as RPA. We're going to speak about how RPA fits into the wider legal tech landscape. We'll spend a while dwelling on exactly what that looks like, and particularly try and find the niche of RPA compared to some other legal technology platforms. Then I've got a video to show you as to exactly how we're using it in-house, something specific that we've created. And so, we'll go through exactly what that looks like. We'll then talk about, and this isn't applied for Dentons really, this is, talking about robotic process automation. We'll talk about how we're training our lawyers, not just with this technology, but others as well. And again, I'm using it. We'll talk about how to choose RPA use cases, because there are many areas that it's not going to be suitable for. We'll talk about some of the risks, some of the pitfalls of using it. And then we'll round off by asking ourselves, well, okay, this has been interesting, but do all lawyers need this? Or some of them, or is it actually meant to be part of the back office function, etc. So let's start off. What is robotic process automation? For me, it is taking tasks away from people, away from lawyers, so that they can do higher value activities. And we've got now 3 principles that we're going to be abiding by for the rest of this presentation. The first one is we're only really going to be talking about using RPA to automate legal activities. I will reference from time to time non-legal activities, so that's from IT and finance and HR functions and stuff like that. But generally here we're talking about what can we actually take away from the lawyers so that they, as is written above, can focus on the higher value activities. Point B, we're talking about things that ideally need to be repeatable. What you don't want to see is RPA being used to automate a process that only happens once as part of a bespoke client matter, or happens only very infrequently. What we're looking for here are things that happen, dozens, hundreds of times, thousands of times, And actually, you can see a really big time saving taking those tasks away from humans. And point C, we like in this context to work with structured data. And I know this is an academic audience, so I won't go into too much detail of what that is. But in particular, we're talking about, is the data frequently in the same place? Is it in the same format? Is it in the same language, that type of thing? If it's in a database, how often is it around? What we like to see is, static, always in the same place, it would be documents and things like that. And if we can adhere to all three of these points, then potentially we might have a use case for RPA. Okay, so that was like a very brief intro. I'm now going to go through a few different categories here of legal technology and talk about how they tackle automation. And hopefully by the end of this slide, we'll have a good idea of the niche of RPA. So when I'm talking about all these things, just try and focus on, okay, so if this is automation in transaction management, if this is automation in life cycle, then RPA sort of has a score down here. Okay, so in terms of transaction management, and I've got a couple of examples here. So checklist automation and verification automation. So if you think about a banking transaction, you will have typically a couple of banks and the clients and the law firms all trying to gather all of the relevant documentation before the, say, loan is released, until the money is released. And so that would be, say, conditions precedents checklists, which would be gathering articles of association, board minutes, joint venture agreements, or whatever it might be, and making sure that everyone's happy with the contents of those documents and that everyone has the right versions agreed. And that would before have been lots of emails flying around, maybe in a central sort of Excel spreadsheet. And the way that there's online platforms now that can essentially automate not only the production of this list, but also creating a private outlet as well. We use the Gatix, there's also Workshare Transact as well. And so, that is a specific piece of automation relating to banking transactions. And for verification, we're talking about documents like prospectuses or other initial public offering IPO documentation, where the law firm needs to actually go in and verify the veracity of each individual statement that is made in that prospectus. And so what that might have been before is printing out the document, circling each sentence or paragraph or page, but certainly could be each sentence, and assigning that sentence out to a lawyer who would then have to go and check, can I find proof for this statement? And therefore, if I can, we can keep its inclusion in the prospectus, which is sent out to potential investors. In terms of automation here, there are platforms, Atticus, ScribeStar, that will automatically go through the document, split it up into sentences, and assign those out to the lawyers. They can easily put their evidence behind each statement, and that creates an automated document at the end of it where you can sort of go through the prospectus, click on each sentence, and take you to the evidence. And so again, we're talking about tools which are time-saving for lawyers, but not RPA. Right, moving on to the next one, document life cycles. What do I mean by that? I'm typically talking about drafting documents, negotiating documents, or signing documents, or storing documents as well. So it's typically a mix of those things. And so a couple of examples here of automation in this field. There are tools like Define or Contract Companion that will go in and for your document, put out all of the definitions and say whether they have corresponding entries in the definition section of the documents, and vice versa, whether our definitions at the front and they're actually not referenced in the body of the document. So a trainee typically would have had to go in and do this check themselves. It can be quite time consuming, but now the software can do it automatically and show you, okay, you need to put in definition here, remove this, or add this, and it saves a lot of time. Could potentially have actually been a robotic process automation use case, but there's already a product that does this, so we're not trying to reinvent the wheel. In terms of knowledge management, what we've got in this particular instance is I'm going to be talking about tagging documents. So what we try and encourage our lawyers to do, towards the end of transactions is think about what collateral, what documents have I produced that could be useful for either me or my colleagues on future transactions. And so what they do is they go into the document management system, right-click on the document that they think, okay, this could be good knowledge, and click Submit to Knowledge Management System as a button. Then what pops up is a box saying, please tag this document on the basis of this specific taxonomy. Is it a corporate document, is it a banking document, is it a disputes document, employment document? And the idea of automation in this space is that tagging process can be quite time consuming and possibly to the extent that actually discourages lawyers from wanting to go through that process in the first place. So automation in this space is the tagging system learning over time based on the title of the document or the practice group of the person trying to submit the document, or even the contents itself of the document, what the tags might be. So then the lawyer is thinking, okay, are the tags that the system is recommending to be correct, as opposed to having to go and figure what those tags are themselves. In terms of collaboration, a good example here is task templates. So at the beginning of a matter, as long as you have done the work beforehand and thought about, okay, for this matter, what are the 10 or 20 must-do tasks for everyone? What you can do is, when the next matter comes in of this ilk, you can just spin up the task templates, automatically assign them to the rest of the team. And that encourages people to firstly use the task management system in the first place, also saves a lot of time trying to figure out who does what. So AI for document review, or maybe machine learning you might prefer to call it. So typically here, we're talking about a virtual data room that has capabilities of reading the contents of the documents. So it's not just about traditional virtual data rooms that are just simple document repositories. Here, the algorithms actually go into the context and try to figure out, are there any clauses they recognize, data points, and things like that. So automation in this case is, can I get the system to extract and display for me all of the assignment clauses on these thousands of commercial contracts or employment contracts, or these leases? Can it tell me all the termination provisions? Can it tell me all of the liability provisions? And this just, again, saves the lawyer time having to go and find them. So that's what we're talking about. That is the type of automation that AI can do for us when we're looking at reviewing documents, typically in a due diligence context. We have research automation as well. So legislation research automation. Denton's via our Next Law Ventures portfolio, where we invest in legal tech startups. We have a stake in a fund called Librio, which automates the tracking of changes to legislation in different jurisdictions. So let's say a client comes to us, we're thinking of doing a project in this jurisdiction, this country that we've done anything before. Our initial research says that we need to make sure we're compliant with these 3 regulations, but not just now, also in the future. So what they don't want to do and what we don't want to do is constantly be tracking, has it changed, is it, what's changed in this legislation. And so this Librio tool can essentially do that for you. But it's not, you might think, okay, well, if it's just a piece of legislation that's changing, maybe RPA could do that. But actually, it's more complicated because in the most well-developed jurisdictions, like the EU, for example, all of the legislation is digital. But in many jurisdictions, it isn't, and in some, it's even it's very unclear when or if it has changed. And even then, it could be just a notice pinned on a notice board in the local courthouse. And so actually, it fails the structured data test in that instance. And then we've got mapping visualization here. So this is software that will and I think it may only work in the UK, but it's be interested to hear in the questions if there is software similar to this globally. But essentially, for our real estate lawyers, having a map overlaid with freehold and leasehold information, so you can click on a property, immediately see who the proprietors are, and what the address is, and any other information, saving the lawyer having to go to multiple different sources to gather that information. Just sort of rounding off, so we've got legal project management here as well. The automation of the pricing and budgeting tools, it could potentially be seen as RPA. So this is about making sure that we've got a repository of all of our fee earner rates and clients discounts and client rates and stuff like that in an interactive tool, so that the lawyers can easily just plug in numbers for a specific matter and make sure that all the data going into it is correct. We use that generally via things like Excel macros, but possibly RPA could also fill in a gap there. And again, the timelines, just having automatic editable timelines available for lawyers to keep starting from scratch. And then finally, onto automation then. We've got document automation, which is about, can we take a precedent document, like a commonly used legal document that's been approved by our internal lawyers, and instead of starting from that each time, or instead of starting from the last document I used on a specific deal, can I actually turn that into a questionnaire, which, depending on my answer to the questionnaire, will spit out different versions of that document. So, if I answer, if I tick these multiple choice boxes in the questionnaire, it will insert this clause, but remove this sub clause, etc. And it's just a much safer way of starting a matter, as opposed to trying to remove different document blobs and doing Control F, Control faces and stuff like that. So then we have RPA. So again, generally the things that I've been speaking about here will fail one of the three tests. There we go. So, okay, I'm now going to give you an example of how dentists are using RPA. So the example I'm going to use is the automation of a company search report. We have, and this is essentially a Word document that's filled out on a transaction that might be involving 100 different companies, trying to find out things like who the directors are, who the shareholders are, what the address is, what the company number is, the director, company secretary information, whether they filled in that form, whether they did X, Y. And this would usually be performed by a trainee and would take 30 to 45 minutes per company. So if we could possibly automate this, it would be a massive time saving represented. Typically, the data comes from company's house. The output is usually a Word document, and the input that we're interested in is typically just an Excel of all the different company numbers. So I'm going to bring up the video here. So, okay. This is a video of not of the code behind the automation, but just a video of what the automation is actually doing. So the first thing that we're seeing here is person goes in and types who the requester is. In reality, this is actually part of our portal, and so it's already notes who it is, but just for purposes of this demonstration. So having a look at the company numbers, it's pulling up that spreadsheet, and now it's asking us where am I putting it into, and then where am I saving it down to. Okay. So I'll just skip a little bit forward. So the company we're doing is going to be Denton's, just the purpose of this demonstration. And what we're actually seeing here is the machine is going through all of the different places where we've pre-programmed it to look, and it's copying a whole host of information onto the clipboard. So you can see it doesn't look like it's actually doing much. But actually in the background, it's going into all of these different tabs, all of the different documents in the filing history tab, and it is copying lots of different information to the clipboard. So this is the search form. So let's see now what the machine is going to do. This is all automatic, by the way. The user's totally stopped interaction now. So actually, as you can see here, we've got different placeholders for company overview link, company name, company number, requester, nature of business, previous names, generic contact information. You can see lots of placeholders here. And it's the machine that has actually gone into company's house, found where they are, and is now going to insert them in. So you can see here, there's automatic requester. Let's get it grabbing the company name. Just skip forward slightly. So now it's having a look at for the statutory register section. It's actually going through and checking on company's house. Did it have that form and not that form? Did it have that form? That form, and it's a bit of logical interface here to actually check whether it's one or the other. You can see it's the no that it's taken here. And now it's calculating, has the company filed one or more forms on or off the state? So again, a bit of relatively basic factor information, but still to have to check that. Now it's pulling up, previous names, direct information, accounts overdue, filing information, who the shareholders are, and it's going to grab those now. Obviously, it's all public information, and then by the end of it, we'll sort of finalize the document. But hopefully, from there, you can see roughly what it is that we're talking about when we're referencing trying to save fee owner time, because the fee owner in that case didn't have to really exercise too much judgment. It was about going into company's house and trying to just find the right information, copy and paste it into the right form. And as I said, it could potentially be hundreds of these done per transaction. So we're talking about potentially we haven't managed to automate 100% of the form, quite a long form, but I reckon 80% of it, and we're sort of increasing its complexity. And now if we think back to the three tests, obviously the first one, this is a legal task, it's something the lawyers specifically doing. Repeatable, because it's done quite frequently. And in terms of structured data, this company's house website, which is the UK website on company information, the data is always in the same place. So the URL is always essentially company's house, or whatever it is, / the company number. So it's always easy to find the right site. And the filing dates and the director's information is always displayed in the same place. So the machine is able to actually go and grab that information. There is actually a company's house API, which we are also experimenting with. But just for the purposes of this, it's good to show what you can do when there is no API. So you might be thinking, well, hold on a second, what about the documents listed on the website like this? So that's where it gets quite interesting. We are actually using the RPA to extract information from those documents as well. But we're using, well, firstly, they're all scanned documents, so we need to use optical character recognition technology to render that more machine readable. But within those documents, the format is also the same. So it's not like we're having to go into the annual reports and the annual accounts because they will be bespoke per company, and there's not much we can teach the RPA to actually render from those documents. But yeah, so hopefully that was interesting. You know, a task that saves our viewers a lot of time, very repeatable, and the data that goes into it is structured so we can at least rely on the rest of that information that is completed in company's reports. Okay, so we've got here just a quick sidebar as to our innovation training scheme. And this is about how are we training our lawyers to get to know not just RPA, but some other very interesting pieces of legal techniques. The first thing we do is we give them these e-learning modules to do before they join the firm. So at the moment, this is for all of our trainees. Well, certainly will be from September, all of our trainees. And we collaborated with a leading local law school, BPP, to actually put together these e-learnings. So we've got introduction to technology, introduction to design thinking, intro to innovation, intro to system design and data, and then process mapping as well. So the idea is before they join, they all have to do all of these e-learnings. And then the minute they get in the building, in their first seat. So for those of you who are unfamiliar, the way that the training contract works in the UK is it's 4 times 6 months, so it's a 2-year scheme, and they have to change departments 4 times. So for these practical exercises, they have a menu of 7, and they have to do 4 of them over the 2-year period. So, you know, we've got down here, as you can see, use RPA software to automate a simple process. So this is definitely part of the training scheme. We've got here train up our AI system, which is Luminance, and I know other dentists regions use Kira, and there's actually lots of tools out there. We've got Contract Express to automate the document. This is what I was talking about before in terms of the questionnaire. A legal design thinking hack of a document type. So this is actually not technologically related at all. This is about can we optimize the visuals and the visual representation of some of our legal documents. So one of the trainees who did this actually turned a 5-page client memo into a flowchart. So the whole document turned into a flowchart. Client found it a lot more relatable. It was meant to be a document that was frequently used. Having it in that flowchart format allowed them to actually utilize it more effectively each time. And we've got data visualization as well. So this is about can we use AI to garner insights from our department documents. So, for example, you know, can we grab 200 or 500 share purchase agreements that the firm has worked on in the last 5 years or whatever, and say, you know, for these documents, can we get insights per client or per sector or per industry on any clauses that are appearing in the documents, or you know, or maybe disappearing, or the amounts going up, the insurance amounts going up, things like that. And actually trying to take advantage of the breadth of data that we have available at the law firm, possibly for, you know, just internal insights, but also for market-facing research as well. And obviously here we have the RPA module. And what I didn't say before about the previous example was actually it was 2 trainees that came up with that. They learned how to use the software. We told them how to use the software. And they decided on a use case and actually built a prototype as well. So after that, we've had to get some of my team involved. And we also had 2 RPA engineers to help us really grow this business. But it really shows the creativity that young lawyers can actually bring to the table once they're given the right tools and the opportunity. So we're going to talk a little bit now about choosing our robotic process automation use cases. Now, I said before, we can see at the top right, just a reminder of the principles. But talking about legal, you can automate, one way to do it is to focus on the individual practice group needs. So have a session, a workshop with the banking group, with the corporate group, with the real estate group, and lay down on the table a little bit like what I've done today. What is automation? What should I be looking for? And try and tease out some of the repeatable exercises that involve structured data to, and then take those away and work with the team to try and get some of those things automated. Or you can do the trainee, the junior lawyer approach. So practice group agnostic. Just speak to all of the trainees and paralegals and groups. Try and get them to think about some of the tasks that they're actually carrying out that might be able to be automated. If you want to think about cross-practice group automation, we would recommend doing workshops directly with partners, the ones that are most likely to have the cross-practice relationships. And then as a catch-all at the bottom, we've got idea competitions. So, sending out, using idea software or just by email, a message to the whole firm saying, here's a short description of what automation is, here's what we're looking for, please everyone submit your ideas. So there's a few different ways of getting to those use cases. Now, talking about functional, by functional I mean non-legal. And actually Adam mentioned before, what does non-lawyer mean? Well, typically a lot of people in my role formerly were lawyers. But actually, I think there's now myself and a great number of people who haven't practiced law, who are able to nevertheless perform this legal innovation role. So that was just a quick sidebar. But in terms of using RPA in IT, in HR, in finance, in business development, all corporations have these departments, and actually have some industries have been doing this for quite a long time. And so when I'm talking about well-defined market, there's lots of examples out there of how to use robotic process automation in IT, in HR, whatever. So you're looking at invoicing systems. So the invoices that you as a company are sending out typically always look the same. So that's great for robotic process automation to scan incoming invoices, to try and apportion them directly to your accounting system. We've got accounts reconciliation, automatic invoice sending or just receiving, adverse media scans for the Know Your Client or anti-money laundering legislation, payroll processing, user permissions management. All of these things involve very repeatable structured data tasks. And there's lots of information out there. We're not going to go too much deeper into it during this presentation. The other thing that you can do is speak to implementation consultants. So RPA for legal activities is pretty new. But as I say, for this is quite well developed, and there's plenty of RPA implementation consultants out there that will be able to help you on that journey. So, an example to think about maybe the pitfalls, the dangers or the risks of RPA. Will RPA work for contract management? So we've had a look before at the company search form, and that works quite well. But let's look at an example lease. Contract. So I've grabbed this lease from just randomly available online. We've got in here, I've done the Adobe fill and sign. So all I've done here is start to put down some information. So lease shall terminate on 2022, for example. So we can see here there's actually a lot of gaps for us to fill in, and if we just take it at face value and as a potential tenant we just fill it in and accept terms, then that can be very interesting for RPA. What is the rental allowance? I've put those in here. I've got the term date, the termination date. You can see there's lots of different gaps here that I can fill in. And as a landlord, I might have 1,000 tenants, and they would all be able to fill in this lease. And there would actually be quite interesting to see whether a platform would be able to just extract all this information for me and tell me, okay, for my 1,000 tenants, what will the term start dates for the leases, when are all the termination dates, how much I'm paying, and like I say, it's spreadsheet format. And this would be, save me loads of time to go into each lease and check them and set reminders and things like that. So if that's what we're going for, then it could actually be relatively interesting. But there are some risks. That was our template. What if we're using third-party templates? Then immediately the RPA would fall over because it fails a structured data test. We would be able to teach for our template, we'll be able to teach the RPA exactly what to look for. But as soon as that template changes, then the whole thing falls apart. Similar with major edits to your template. We're just thinking about the use case of if the tenant just accepts all the terms, and that's one thing. But if they make any changes and to particular clauses or particular data points that we're interested in, the whole thing gets much more difficult. Again, handwritten dates or names or edits, very common with leases. I just did the Adobe text entry, but some people may decide to print and scan. Very, very difficult for RPA if we're introducing those sorts of changes. Similar for attachments or appendices, any extra references that we've not taught it, again, it's not going to recognize it. And this introduces risks to the process because that might happen and the machine doesn't find anything, gets the wrong information, you're not necessarily going to know about it. And yeah, talking about changes, so DIDS variations is how we deal with changes to leases in this country. And again, so it wouldn't necessarily be able to map any changes from one lease versus the deed. And suddenly our contract management system is actually looking a little bit patchy. So instead, could we use AI for this? And we do. We do. Well, we don't have a contract management system like this, because we're not massive landlords, for example. But certainly, we do a review of a lot of leases, and we use a system called DealSum, and again, other regions use Kira. And what we're asking ourselves here is, okay, obviously the template lease that we start with, that we send out, is our ideal positions for everything. But we want the contract management system or the AI system to tell us if by the time the final contract is negotiated, what has changed, and in particular, what has changed with regards to what we would find acceptable. So has the liability clause changed from the original position to a fallback A position, or is it a fallback B position, or is it some other bespoke position that the client has to sign off on and has been lots of back and forth on? This is valuable data for us. Why? Because if we figure out that there's a particular clause in our lease, contract or whatever, that constantly changes, that never get accepted by the other side, we may want to actually just change the position itself. If it's just wasting valuable negotiation time, we might decide it's not even worth it and just change it from the outset. And this is something that our Helix managed services offering does really well for clients. But in order to do this, we need to go down to each clause level in great detail. And so this, even using AI for contract management at more than a basic level, gets quite difficult. Anytime that you're introducing very, very minor changes that can have very major impact. So even adding one word to the clause can flip the whole meaning. And so AI needs to be able to recognize that. And I think that is somewhere that AI is not currently able to do effectively at this moment in time. So we're just going to round off now before we take some questions. Should all lawyers have to learn how to use RPA? And so hopefully this has been like an informative talk on RPA, how it fits into the wider legal tech market. And so, to address this topic, it is harder to automate work at the senior end. There is no doubt about that. But at the same time, senior lawyers do have good ideas for more complex automations. And I suppose the point is that we teach our junior lawyers more for longer term understanding and trying to turn them into what the process automation coders. And we're actually seeing the benefits of that already. So the trainees that did this module in their last seat are taking those ideas into their current seats, in their current departments, and suggesting some really interesting examples of either using this technology or combining with some of their colleagues to have more holistic solutions. And so it's not just about the initial training for these specific robotic process automation platforms, but actually as they go through their careers, to have a good knowledge of all of the technology that's out there, we think is extremely valuable. And so we think that as the trainees progress through our business, and all of them have learned how to do either this or document automation or AI systems or design thinking and have this well-rounded knowledge, they will actually be able to think in different ways in terms of client delivery. And that's what we're going for. And I think that's all I've got for this presentation, but really keen to hear those questions. I don't know, Adam, if you're going to have anything.
Great. Thanks so much, Joe. Very interesting talk, I think. Also, if I could just say that at Swansea University, where we have a legal tech LLM, we're teaching law school students some of these topics, and I'm very pleased to hear the kinds of things that you do with your trainee law staff is very much on target. So it's clearly an area where law schools and law firms are very interested in teaching automation in various dimensions. Let me just ask the organizers of the platform, did they gather any questions from the audience? Because I didn't get any on my side, although I can ask a few just to come up with. So if Alina perhaps will chime in. Not sure how that part of the presentation was going to be handled. No? Okay. Well, then I'll just ask a couple of general questions. I found it really very interesting, to get an overview from you about what's going on at Dentons and the kind of work that you do. I guess one general question I had was about structured documents. You gave us some instances of structured documents. The main focus that you mentioned was that there's a constancy about the documents, where they're located and the fields in them and things like that. Mm. Are there discussions at Dentons about using machine readable documents, that is using knowledge graph or markup languages or these kinds of things that provide you with semantic information in a structured manner about documents and harvesting data from them?
It's an interesting question, actually. It's something that we've been thinking about, but it does, in order to, it really is a huge shift in the way that lawyers work. It's not, a lot of the stuff that I've been speaking about today fits into, roughly fits into existing working patterns and identifying sort of one change at a time. For example, thinking about AI systems, it's about, lawyers will still be able to view the documents if they want to, but the AI will be able to bring out the clauses for them. Trying to doing what you say, which is basically going to right to the beginning and saying, you have to use this system for document drafting. In fact, some people are proposing industry-wide wording for document sets, and that works well with things like LMA. They've got the one NDA thing, which is also potentially very interesting. I think it's something that we're keeping an eye on. I do agree that there's a lot to be said for having much more document standardization across law firms. It would, I think it would be beneficial for a lot of different parties.
That's an interesting remark that you're sort of leading towards, because there's a big advantage to having standardization and adopting standards for all sorts of document representations, but it also presents a bit of a challenge, because firms kind of make a good deal of their market from unique documents, right? By in effect, saying, we have specific bits of information. So there's a bit of a tension between saying, we'll use standards that are, exchangeable bits of information versus how do we keep our clients close to us because we're offering something unique. How do you manage that sort of situation?
Oh, I mean, look at the LMA, how the LMA documentation has revolutionized banking law. It's not, our banking department in terms of headcount and profit and whatever, it continues to grow, and the client relationships remain intact. So I think that once everyone is in the same boat, I think that it's, it has benefits for the industry.
Right. So you move off into some other aspects of the business rather than the unique structure of the document.
And knowledge is not just documentation. Knowledge is also, personal experiences, not knowledge that isn't deliverable. So internal guidance, practice notes, advice notes, other research tools as well. So it's not just about precedents and precedent management.
Great. Okay. Let me slip in one other question, and then we'll take some more questions from the audience. There's a few coming in. I'll just ask one more. What are some of the biggest challenges that you see coming over the horizon for Dentons and for applying automation?
Well, some of our lawyers seem to think that we're moving at such a pace that we're not going to have anything automatable left, which I think is not going to be the case. There'll always be something. What are the biggest challenges? I think just getting enough buy-in to some areas where, that there may be a bit of internal resistance, as there will be, not just at all law firms, but all companies for this sort of thing. Capacity, to process all of this stuff. The way that we're going to be structuring our robotic process automation dedicated engineers is going to be half legal, half non-legal stuff, so half back office. So there's always going to be a few different things there to manage. But yeah, we're very excited about this RPA journey and how it's going to hopefully make a big difference to the lives of our lawyers.
Great. Okay. Thank you very much for addressing my questions. Let me turn to the questions from the audience. One question is, does the Dentons team create the training that's given to trainees and lawyers? So is it all built in-house for your trainees and for your lawyers?
So the e-learnings that I was talking about before, they are that we started with some stuff that BPP had done and tailored it towards us. So I think that there is a legal technology innovation and design course that BPP offer, which is it's the basis of the ones that we have. For the practical tiers, all of it is our stuff. The processes that people have to follow, we basically had to write. The technology isn't ours. Let's just clarify. We don't own Contract Express. We don't own Luminance. We just use the products, and give them to the robotic process automation tools we use. By the way, are Microsoft Power Automate and UiPath. So and I'm sure there are other tools out there as well. Yeah, we don't own any of them. It's just about putting them in the hands of our lawyers.
Okay. Thank you. And there's another question that's also about training. What are the biggest pedagogical challenges in training lawyers in this area, and how do you think you can overcome those challenges?
Yeah, so I think, it's an interesting question. I mean, before we did this scheme, there was a huge knowledge gap as to, what the possibilities were. And so that's basically why we've done it in this way. For me, I would say the most important bit of the training is the practical exercises bit. We think this sort of distinguishes our scheme. And I would say that a big challenge would be having just the e-learnings and not the practical. That I think is the most important thing. Getting the lawyers hands-on with the technology is the best way to overcome, oh, okay, I see that this is there, you're telling me about these different tools, I'm doing e-learning about these different tools, I'm even, attending firm-wide webinars about this technology, that technology, but until you use it, it's not real for you. And I think that is why we've gone down the route of, it's not forced innovation, because whilst they do have to do it, they've got quite a wide remit to do, basically whatever they want. They make their choices as modules, they make their choices as to the use cases. So there's plenty of creative freedom to be had there. But just the mere fact of, having to learn how to use Contract Express or learning how to use Luminance, we think has massive benefits, not just for the training scheme, but as I've said a few times, benefiting not just them throughout their careers, but also the future of the firm.
Okay. Actually, if I could just follow up on that kind of question, to me, it's a bit interesting to explore the conceptual difficulties that trainee lawyers have. And I'll just talk a little bit from my experience and point of view. At Swansea, I have a course in computational thinking for the master's students in the law school. And, we teach them a bit about how to take a problem and decompose it into its parts, and what are the relationships between the actors and the actions and the objects, and then try to teach people a bit about abstraction. So it's not just one specific instance that you're talking about, but a lot of instances that may have small variations, but then when you sort of look at this a little bit at a higher level, there's similarities across the board. And then also some things about how do you apply a logic. So if you have this and that, then something else follows. So those things I find for some students are rather difficult. Those are different levels of abstract thinking on top of the specific material. Are those kinds of conceptual issues things that you find, or are there other ones as well that you find that your lawyers have difficulty with?
It's interesting. It is very interesting, the point you're making. And what we actually find is, because typically the trainees tackle, they get to choose their own use cases, they tackle things which they have done themselves. And so there's no conceptuality there. It's that they inherently have been, frustrated or whatever, thinking, oh, I've got to do these 100 documents again or whatever. Right. And so actually, I see what you mean by we could make this very abstract. And that's sort of why the e-learnings are good to start, but in order to really drive it home, as I'm sure you do, I'm sure there's practical exercise in your course as well. It's very important to, but in this case, it's even more so because it's not something which they've having to learn how to do one way and then automate, say. It's something which they've already been doing. And so we don't at the beginning of each seat, that's not when the training course starts. It's after a couple of months, so they've got a few, to get bedded in and to start thinking about what they might be doing.
Okay, terrific. Are there any other questions from the audience coming in? I haven't seen any in the meantime. Just wait a sort of pause for a second there for something to come in. Okay, well, that looks like that. Thank you so much, Joe, for coming and telling us about what you're doing and what Denton's doing. There's a tremendous amount of activity in the legal tech space, and I think that academics who sometimes are involved in rather abstract-looking formal approaches are still very interested in what's going on in industry. So much has changed in the last 4 or 5 years, and increasingly there's sort of like an integration of different ways of thinking. So we look forward to hearing more about what's going on and sharing more when we get the opportunity. So thank you very much again, and I'm sure the audience thanks you as well.
Fantastic. Thanks, Adam, and thanks everyone.
Okay.
Have a good day. Bye. Enjoy the conference. Bye.